The broadcast is now starting. All attendees are in listen-only mode.
Hello, everyone, and welcome to today's session, Enhanced Sentencing under the Tribal Law and Order Act, a webinar by APPA and Tribal Justice Institute. Today we're joined by the Honorable B.J. Jones, Executive Director of UND's School of Law and Tribal Judicial Institute, as well as Nan Benally, who is the APPA Tribal Grants Manager. Just so everyone knows, there will be a recorded version of this made available on our website and on youtube.com. Probably a couple days from now, after we get a file uploaded and recorded, we'll get it on YouTube for you guys. So if you want to watch it again or share it with a coworker, feel free to do that. Before I introduce today's speaker, I'd like to say that this project is supported by the Bureau of Justice Assistance. The Bureau of Justice Assistance is a component of the Department of Justice Offices of Justice Programs, which also includes the Bureau of Justice Statistics, the National Institute of Justice, the Office of Juvenile Justice and Delinquency Prevention, the Office for Victims of Crime, and the SMART Office. Points of view or opinions in this webinar are those of the author and do not necessarily represent the official position or policies of the U.S. Department of Justice. I'd like to introduce the first speaker today, and that's B.J. Jones. He has over 25 years experience as a tribal judge for various tribes in the Northern Plains areas. He currently serves as Chief Justice for the Sessatonwa-Peyton Ayo and its treatment court. In addition, Jones teaches criminal law and jurisdiction in Indian country, as well as a seminar on the Indian Child Welfare Act at the University of North Dakota School of Law. As well, with B.J. Jones, we have Nan Benally with us. And she has spent a lifetime acquiring experience around passionate and purposeful people in the tribal community. Through her experience in education, Nan has granted training in various therapeutic treatment modalities and had the opportunity to participate and present her work in professional venues and in gender community networks and alliances for the support and fulfillment of project goals. Nan has continued her passion for learning as a doctoral student with focus on neuroscience and neurological disorders with veterans and has her Master's of Counseling degrees from Arizona State University. And with that, I'll turn it over to B.J. Jones, and we'll get things underway.
Hey, thank you, Travis. Always like when Travis introduces me, and he has a unique way of saying the Sissanawapan Oyate, but I like the way he pronounces it. But as Travis mentioned, Nan and I want to talk today about one specific aspect of the Tribal Law and Order Act, and that is the tribal authority to implement enhanced sentencing. And if you notice, we choose to use the term enhanced sentencing. I know many people refer to this as felony sentencing. We've encountered some issues with that. It's just in Wapaton where we do enhanced sentencing because we're part of the Tribal Access Program. We've committed to putting our convictions online, and many states, for example, don't allow felons to vote, and we encountered that situation. So there's a discussion right now about whether or not these tribes that have decided to impose sentences that are felony type sentences, whether or not we're imposing that additional civil bar upon people voting and exercising other rights. So that's one of the things that we're going to discuss a little bit in the curriculum when Nan and I talk about what we're trying to accomplish with this whole curriculum that we're going to develop on enhanced sentencing under the Tribal Law and Order Act. But as you can tell from the next slide, what we'd like to talk about is give a brief overview of what the Tribal Law and Order Act allowed tribes to do with regard to expanding their sentencing authority. Before the Tribal Law and Order Act was passed in 2010, under the Indian Civil Rights Act, tribes were limited in the imposition of sentence. The maximum sentence for a criminal offense was 1 year under the Indian Civil Rights Act. TILOA amended that and now allows the sentences up to 3 years per criminal charge or up to 9 years for a criminal transaction. There's still some questions about what exactly that means, what the 9-year maximum applies to. Most people believe it means that a tribe could impose up to 3 years on separate counts of one criminal transaction. But the federal courts eventually probably will have to resolve that issue. So I'm going to talk about how enhanced sentencing came into being under the Tribal Loaner Act, why it was passed by Congress. And then Nan and I are going to go over a curriculum which we're trying to develop for tribes that are interested in enacting enhanced sentencing, or for tribes who are actually doing it. That's one of the shortcomings I feel we have. We really don't have a good idea of which tribes are implementing enhanced sentencing currently. I know the National Congress of American Indians and the Tribal Law and Policy Institute have a list of tribes that they believe have enacted codes that permit them to exercise enhanced sentencing. When we've reached out to many of them, there have been some real questions about whether they're actually done this. Many of them have enacted codes, but they haven't had cases. Others have had cases, but there's a question about whether the code that they have in place is consistent with the Tribal Law and Order Act. And we're a little concerned because I think for tribes, this is an exercise of their sovereign rights, and we always have to treat sovereignty with a certain degree of almost jealousy, that tribes need to make sure they exercise their sovereign powers. So as we look for Congress to recognize even more inherent authority of tribal courts, we want to really be jealous about the authorities we have now. We want to make sure we have a good landscape of who is actually out there exercising this authority. And then we want to lead up to, at the end of this webinar, to try to develop a intertribal working group for tribes who are doing enhanced sentencing. Many of you on the call may be familiar with the intertribal working group on special domestic violence criminal jurisdiction that the National Congress of American Indians currently has in place, where they have monthly calls with tribes exercising that jurisdiction. Tribes can talk about some of the issues that have been coming up, but the primary purpose of that is to coordinate, to make sure tribes get a resource to help them exercise this power, this authority, in a legal way, but also in a way that is meeting the needs of the community. So we'll talk about that at the end of the webinar, but we really would like to do that. And in fact, if anybody on the call is going to be in Palm Springs for the Indian Nations Conference, we're going to be conducting a pre-conference institute on enhanced sentencing. So that's the primary purpose of this webinar, is sort of a kickoff to see if we can develop an intertribal working group. So next slide, Travis. As many of you on the call may know, the Tribal Law and Order Act was passed in 2010. It's interesting legislative history. It was actually passed as an amendment to the Indian Arts and Crafts Act. And that sounds a little odd, but sometimes legislation gets passed in strange ways. But its primary purpose was to provide tribes with more authority to make sure that there's safety in their communities. And one of the benefits of this law, as you'll see from the next slide, is it recognized that tribal courts have been historically underfunded. The primary source of funding for tribal courts prior to 1998 was the Bureau of Indian Affairs. And in 1998, the Department of Justice started funding tribal justice systems through what is now called the Coordinated Tribal Assistance Solicitation Program. There's an aspect of that called the Tribal Court Assistance Grants, which is, I think, is Category 3. So there was a recognition in TLOA that not only do we have to recognize more tribal inherent authority over crime, but we also have to fund tribal courts more appropriately. But some of the findings that Congress made that supported enhanced sentencing or an extension of tribal sentencing authority was that the federal government was declining to prosecute about 62% of the violent crimes that were reported to the FBI and other federal agencies that were occurring in Indian country. And the reason this was a great concern was because when TILOA was passed in 2010, even if the tribal court was dealing with a serious crime such as murder, sexual assault, rape, the maximum sentence the tribe could impose was 1 year. So if in fact the federal government was not prosecuting serious violent crimes and that onus fell upon the tribe to do it, it made little or no sense for the tribe to be restricted in its authority to impose sentences. I can recall prior to TILOA, for example, hearing cases involving the death of tribal members. I recall a case where a young tribal member was killed by a drunk driver. For some reason, the federal government did not prosecute that crime, even though it is an involuntary manslaughter, could have been prosecuted under the Major Crimes Act. It was left to the tribe to prosecute it. And unfortunately, under our code at that time, the only thing we could prosecute for was reckless driving. And I still recall the looks on the faces of the family of that young person who died in that car accident when I imposed the maximum 30 days upon a person who had killed their child. And so one of the recognitions I think Congress had when it passed TILOA was, if the feds aren't prosecuting these crimes, we've got to give tribal courts more authority to impose appropriate sentences. And the other thing that Congress recognized was in Public Law 280 states, was the states and the tribes have concurrent criminal jurisdiction. Some states weren't paying enough attention to Indian country crime, and certain states weren't prosecuting these crimes sufficiently. So TILOA applies equally to both 280 and non-280 states and allows tribes in both of those states to enforce their criminal jurisdiction and impose appropriate sentences upon defendants in the court. So these are the two primary reasons why Congress decided to recognize expanded sentencing authority. A, the federal government wasn't sufficiently prosecuting these cases. The states weren't sufficiently doing it. So tribes were given that authority to do it. Next slide, Travis. Subtitle C of TILOA, Section 234, deals with tribal court sentencing authority. And what that section says is that tribes could impose enhanced sentencing, meaning sentences in excess of 1 year, up to 3 years, and also could increase fines, which were tapped at $5,000 under the Indian Civil Rights Act prior to TILOA, in two types of criminal offenses. Type 1 is what I call the habitual offender section. A tribe could impose felony type sentencing, enhanced sentencing, upon criminal defendants who have been previously convicted of the same or comparable offense by any jurisdiction in the United States. The most typical use of this is usually in the area of domestic violence. And in fact, there's actually a federal statute that allows even the federal government to prosecute a person in federal court who commits a domestic violence offense if they have prior offenses. So this would allow, for example, a tribe to impose a sentence up to 3 years upon a person who's convicted of domestic abuse, who has either 1 prior conviction, 2 prior convictions, 3. This is totally in the discretion of the tribe how many prior convictions. But it has to be premised upon there being a prior conviction in another jurisdiction. Now, if you're a tribe that actually exercises special domestic violence jurisdiction, as you will note, this actually may also permit tribes to impose felony type sentences upon non-Indians who commit domestic violence in tribal communities, provided, of course, that the conditions of the Violence Against Women Act are met. And many of you know that means that there has to be some showing of some type of consensual relationship the non-Indian has, either lives with a tribal member, works for the tribe, or some other aspect of consent. But this is a great recognition of tribal authority to prosecute habitual offenders. It doesn't just have to be domestic violence. Tribe theoretically could impose a felony type sentence upon people who have prior convictions for driving under the influence. I know my personal experience, Sisseton and Wahpeton, where I'm the chief judge, we've been exercising enhanced sentencing now for about 3 years. Prior to about a year ago, we did not have many cases. We probably had maybe 20 cases over the first 2 years. About a year ago, the tribe decided that methamphetamine was such a problem in the community that the tribe decided to make methamphetamine crimes felony type offenses, punishable by up to 3 years for manufacturing, distributing, possessing, and initially even ingesting methamphetamine. Well, our number of felony or enhanced sentencing prosecutions increased dramatically. I think we've had over 100 since that law was passed. And the tribe actually, because we had so many, recently decided to make ingestion a misdemeanor, not a felony. So you've got great discretion within the tribal system to decide which particular offenses can be subjected to felony prosecutions. Now, the other type of offense that a tribe could make subject to enhanced sentencing is any offense that would be punishable by more than 1 year of imprisonment if prosecuted by the United States or any of the states. So in essence, this means the tribe could make an offense punishable by an enhanced sentencing in a situation where the tribe could point to the United States or any of the states of the United States that makes it a felony or makes it an offense punishable by more than 1 year. And if you look at this, this actually gives tribes great discretion to impose enhanced sentencing. Many state codes make drug offenses felonies. Domestic abuse could be a felony under some state jurisdictions. So again, this Tribal Law and Order Act, this section of it, really gives the tribe great discretion to impose enhanced sentencing. However, as we'll talk about when we talk about the curriculum, it's absolutely critical before a tribe looks at imposing enhanced sentencing that you assess what kind of infrastructure you have to impose these kinds of sentences. Because once you start locking people up for up to 9 years, you have a duty to make sure they're locked up in facilities that are humane. Many tribal communities have tribal jails that quite frankly are inhumane facilities. And the thought of prosecuting and incarcerating someone up to 9 years in one of these facilities probably violates the Indian Civil Rights Act prohibition on cruel and unusual punishment. So I think it's critical, even though this is an important aspect of sovereignty, to exercise this authority. You have to look at what kind of infrastructure you have in your community before you decide to do this. I know that recently, about 2 months ago, we had a young tribal member. He actually was not a member of the Sisseton and Wahpeton tribe. He was from another tribe, but he had several sexual assault allegations and some methamphetamine charges against him. And the sentence we eventually imposed upon him was a 9-year sentence. However, we did not have a jail ourselves. The Bureau of Indian Affairs had shut down our tribal jail due to it being inhumane. And we rely upon the BIA, therefore, to incarcerate long-term prisoners in other facilities. And then we were taken aback when we learned that the Bureau of Indian Affairs has a policy that they will not incarcerate long-term people who have mental health issues. And this young man had some serious mental health issues. He's actually sitting now in a county jail for 9 years, and the tribe is having to pay for it at about $65 a day. Those are the kinds of infrastructure issues you need to look at before you decide whether you want to exercise this jurisdiction. So these are the kinds of crimes that you could impose enhanced sentencing upon. Next slide talks about what are the procedural requirements if a tribe wants to enact enhanced sentencing. And what Congress did, it amended the Indian Civil Rights Act. The original Indian Civil Rights Act did not require tribes to appoint legal counsel for indigent defendants. It only required tribes to allow defendants to be represented by counsel. But there was no requirement that the tribe would find or appoint counsel for indigent defendants. If you want to exercise enhanced sentencing, that's changed. You have to provide effective legal counsel for any indigent defendant that comes before the court. This would include tribal members, members of other tribes, or even non-Indians if you're looking at imposing enhanced sentencing upon a non-Indian, for example, who an habitual domestic violence offender. Now, unfortunately, Congress didn't clearly define what the qualifications for a court-appointed defense attorney for an indigent defendant looking at an enhanced sentence. All it says is that the attorney representing a defendant has to be licensed to practice law by any jurisdiction in the U.S. that applies appropriate professional licensing standards and ensures the competence and professional responsibility of its licensed attorneys. Now, many people believe that TLOA demands that tribes provide state or federally licensed attorneys to represent defendants in tribal courts. Other tribes have pushed back at this and said, well, we have our own bar association. If there's an attorney licensed to practice by a tribal bar, and that attorney has sufficient experience, then a non-state or federally sanctioned attorney could represent a defendant in a tribal court. Because I understand many tribes, especially some of the more traditional tribal courts, do not utilize law-trained defense counsel that much. And so there's an ambiguity in TLOA, whether or not the tribe actually has to provide an attorney who's licensed by a state or federal court, or can you provide an attorney that's merely licensed by the tribal court, but who does not have an experience, who does not have a law degree. My opinion is the way Congress has defined this, there's no mandate that this person be a graduate of a law school and be a member of a state or federal bar. However, we probably don't want a test case to go up to the federal courts where a defendant's gotten a very high sentence and he did not have a licensed attorney under state or federal court. But I can't tell you that this is what TLOA mandates, because if you look at it, it doesn't clearly say that this individual has to be a licensed attorney in a state or federal court. It could be, he or she could be licensed in a tribal court as long as the tribe has appropriate professional licensing standards and ensures competence and professional responsibility. Next thing, the tribe has to ensure that the judge in the case have sufficient legal training to preside over these proceedings, and again, is licensed to practice by any jurisdiction in the United States. Once again, this creates some ambiguity. Many tribes have judges who are not licensed attorneys in state and federal courts. TLOA does not mandate that the judge who's presiding over the case have a state or federal law license. You could have a judge who's licensed to practice law by the tribe, who's the judge in the case, but you have to ensure, either in a situation where it's a non-law trained judge or a law trained judge, that the judge presiding over that proceeding has sufficient legal training to preside over criminal proceedings. And we've been talking amongst tribal TA providers about developing a program at the National Judicial College to train non-law trained judges on presiding over criminal cases to meet this requirement. I'm not aware of a judicial curriculum now to provide this training, but this is a critical thing because many tribes perhaps don't want to utilize law-trained judges. They're more comfortable with traditional judges, non-law trained judges, many of whom who know the community, many of whom have better insight into the dynamics of crime in the community. And I don't want to leave anyone with the impression that TLOA mandates that your judges have a state law license. It's not what it says. Many of the best tribal judges I've met never went to law school. And it's true in the state courts too. Many magistrates in state courts don't have a law license. That doesn't mean they're not good judges though. But if you're going to utilize non-law trained judges as your judges in TLOA enhanced sentencing cases, you got to make sure they have sufficient legal training through some curriculum that they've gone through a training. The next two requirements, tribe has to make sure the laws, rules of evidence, I want to stress that rules of evidence and rules of criminal procedure are available publicly prior to the defendant being charged with an offense that could carry an enhanced sentence. The one area I think that I see tribes having problems with this is rules of evidence. Many tribal codes do not contain very good criminal rules of evidence. Some merely adopt the federal rules or adopt state rules. If your code does not specify what rules of evidence apply in criminal proceedings, you may want to get your tribal council to pass a resolution incorporating the federal rules or the state rules where your jurisdiction is, just to make sure you satisfy this requirement. Because I would hate to see a tribe impose felon enhanced sentencing upon a defendant and have that challenged in federal court, and then the federal judge go online or look at the tribal code and not see any rules of evidence or rules of criminal procedure. Both of those have to be made publicly available if the tribe is looking to enact and enforce enhanced sentencing. Lastly, you got to maintain a record of the criminal proceeding, which the Tribal Law and Order Act doesn't demand that it be a written transcript. That may be the best requirement. It could be a oral recording, a video or audio recording of the proceeding, but there has to be some type of record of the proceeding so that eventually, if this case gets to tribal court or to federal court or to the tribal appellate court, there can be a review. Next slide, Travis. The maximum penalty a tribe can impose upon a person for a criminal transaction is 9 years. The maximum penalty for one criminal count in a complaint is 3 years. So, for example, if someone is driving while impaired by methamphetamine and they injure someone in an accident, and then they attempt to flee the police and they assault a police officer, a good tribal prosecutor could probably find 20 charges against that person in a criminal complaint. However, the maximum from that one criminal transaction hitting someone while impaired, possessing methamphetamine, ingesting methamphetamine, assaulting a tribal police officer. The maximum from that entire transaction can only be 9 years. Some tribes have this policy of stacking criminal sentences, stack them one upon the other to impose maximum punishment. You can stack under the Tribal Law and Order Act, but the maximum you can impose is 9 years for a criminal transaction. For individual criminal count or complaint, it's 3 years. So that's the maximum sentence tribes can impose. Others have asked Congress to just totally eliminate the cap on tribal sentencing authority and allow tribes to sentence just as state and federal courts can sentence. Some tribes don't really have the resources to do that because, as we'll see later on in this webinar, there is an issue about resources for tribes. There are other sections of TLOA I think I talk about in the next slide, Travis. Okay, it's great for Congress to say we recognize tribal authority under its inherent jurisdiction to impose felony type sentences on defendants. What about the resources? How are tribes possibly going to provide correctional alternatives for individuals who are looking at going to jail up to 9 years? And under TLOA, there initially were 3 ways a tribe could impose enhanced sentencing in the corrections arena. Number 1, the tribe could incarcerate someone in their tribal jail for up to 9 years if the tribal jail met standards imposed by the BIA for long-term certification. And the BIA did come out with some standards tribal courts would have to meet, tribal jails would have to meet for long-term incarceration. Number 2, the tribe could enter into an agreement with the state or county for long-term incarceration. We've run into some issues, though, with this second possibility because it's not clear to many people whether the state or county have to meet the same standards the tribal jail would have to meet. Because if you look at some county jails, they're not humane. They don't have humane conditions for someone who may have to serve 9 years in that county jail. But TLOA doesn't seem to require the BIA to certify a county or state facility for long-term incarceration. We're trying to get some clarity on this point because we don't want a tribe to believe that they can just enter into a contract with a local county jail and then start incarcerating people there for sentences beyond a year. And if that county jail doesn't meet standards for long-term prisoners, there may be some liability on the tribe. The third way the tribe could participate in the Bureau of Prisons Tribal Prisoner Pilot Program. And some tribes did utilize the Bureau of Prisons. I don't think this pilot program was recertified yet. So this is not currently, I don't believe, an option for tribes, but hopefully eventually it will be recertified and tribes can utilize Bureau of Prisons. Another warning, though, about this pilot program, similar to how the BIA now is restricting access to its long-term facilities for any person that has a mental or physical disability, the Bureau of Prisons also had a requirement that the person be in good health before they could be placed in one of their prisons. Hopefully this pilot program will be recertified and this will be an option for tribes. Next slide, Travis. There is a provision under TLOA for more funding for tribal jails, and it has been somewhat realized, although as far as I know, there's still no independent funding from the Department of Justice or the BIA to build new jails. But as you can see from the next slide, there are programs for tribes to renovate buildings under the Coordinated Tribal Assistance Solicitation. There's a Category 4, which is called Tribal Justice System Infrastructure Program. And what it does provide is funding for tribes to renovate current facilities and also to develop alternatives to incarceration. Some tribes have used this funding, for example, to build alternative housing for people coming out of prison, or alternative detention centers for people incarcerated by tribes. There's also talk in Taloa about funds becoming available for tribes to build regional detention facilities. I don't think that money's become available yet. The Tribal Law and Order Act has never really been fully funded. The original vision, I believe, was that there'd be resources for tribes to build long-term jails, either on a regional or individual tribal basis. It's not really been realized. It's one of the complaints that some tribes have about Taloa. It's great to allow tribes to expand their sovereign muscles, but if you don't give them the funds or resources to do it, it creates problems. And I think there's another aspect of Taloa on corrections, which is the next slide. Yeah, Taloa does say that there should be made available for tribes monies to construct tribal justice centers. Now, as far as I know, currently, the only monies available for tribal detention facilities is Category 4 of CTAS, and that's to renovate existing facilities, not to build new ones. I am not aware, and perhaps somebody on the call is, of any money that's currently available for construction of tribal justice centers. The Bureau of Indian Affairs and the Attorney General of the United States were directed to develop a report on long-term incarceration in Indian country. There was a report. We have it if anybody's interested in looking at it. There were several consultations before the report was developed, and many tribes in the consultations indicated they would prefer to see alternatives to incarceration. So there's a lot of discussion in that on alternatives to incarceration. Okay, next slide, Travis. Okay, I'm going to turn it over to Nan to talk a little bit about what we're trying to do in the curriculum that we're developing for tribes on enhanced sentencing. And then we can talk a bit about our vision of having these monthly calls with tribes. So I'll turn it over to Nan Benali, who's with APPA, to talk a little bit about what we're doing with the curriculum.
Thank you, BJ. One of the things that we're doing in partnership with BJ is the curriculum that we're developing right now. And so we're going to just give you a brief overview of what that project pertains to and what it's going to be. We're trying to roll that out within this year. So one of the things that we're doing is concentrating on 4 main areas, talking about community readiness. And so one of the things that we're finding out is kind of like what BJ alluded to, is saying that we're finding like a lot of communities are either just now adopting this legislation, or they're still in the process of trying to figure out how their community can best assess the program and also possibly put it to use. And then also when we're talking about that, we talked about the resources and the changes needed to tribal law, how we're trying to look at how different systems are already set up within the tribes and how to meld those pieces together with what is the legislative pieces. Also, we're talking about the tribal justice system. What are some of the changes in the court system that needs to be addressed? You know, we talked about how we're looking at who is considered a member of the court. who are viable judges, how do they need to be trained, or who certifies them, those types of things. And so we're trying to look at all of those things as it pertains, again, to this legislation. And then just what BJ finished talking about is the corrections issue. You know, we're talking about resources in terms of where do we house these people? What types of jail situations do we have? What is the personnel related to that? What are some of the changes that we need to address if we don't have those resources? And who is going to be able to help us provide some of those resources in terms of, you know, whether it's a building or funding or expert personnel to help guide the construction of some of these issues, for some of these issues to be realized. And then we're also looking at victim impact and re-entry issues. And this is a big piece of why we decided to bring this curriculum and look at the overview. As we're doing the overview of this curriculum project, is saying that we're seeing a lot of ways that we're trying to address re-entry issues, and also how this is impacting victims within these communities. How are we addressing the needs on both sides? How are we able to help alleviate some of the cross-jurisdictional issues, the resource issues, and even the ways in which we're interpreting some of these things between federal laws and also tribal laws. Next slide. So when we're looking at this, what we're finding is that somewhere between 12 to 18 tribes may be exercising ESA, but they have no coordinated method of assessing state of implementation. So we have reached out thus far in our work on this curriculum to several different tribes, and we've gathered lists from different people saying that they are either exercising ESA or they're in the process of implementing it. And so what we're finding is mixed information. And so we're finding that some of them, like BJ talked about earlier, are saying that, yes, we do have it, but we haven't implemented it yet. Or we're in the process of implementing it, but we still have some questions about certain pieces of it, and see if how that we should be interpreting some of those things. And also, some tribes may have codes, but there's no active cases yet. While some of our already have active cases or for felony type sentences. And so there's a wide range of different areas of progress in these areas, and we need to be able to at least address from one spectrum to the other. And we also wanted to continue the recognition of inherent tribal authority and where we need to assess where we are. Because one of the things, the primary reasons for ESA is on behalf of many tribes reaching out and saying we need to all get on the same page. We have this legislation, and we need to either come to an understanding of how we each interpret it, or how we should be implementing it across all jurisdictions, so that we have at least some notion of how there can be some similarities and some crossovers that we can be able to address. Okay, next slide. Next slide. And right now, we had talked about, as part of this curriculum and why we're doing this webinar today, is we want to be able to start hosting monthly calls with tribes that are currently doing ESA or are thinking about implementing that in their communities. And so, as BJ talked about, at the Indian Nations Conference in December, we'll also be doing a pre-conference seminar on this project as well. But right now, what we would like to do is we're reaching out to anyone from the communities that you all represent that would be willing to be on these monthly calls with us, just to kind of get your feedback and get your thoughts about where you are at. It helps us to update not only the information that we currently have, but it also helps us tailor the curriculum review that we're doing, so that makes it much more, it speaks more clearly to the needs of the community that we're trying to roll this out to. And so if you know of any tribes that you're aware of that exercise this authority to APBA, please let us know. If you're not able to join us, maybe you can pass the word on our behalf. We're hoping that after the this webinar, we'll try to host another one in December. But if you are going to the Indian Nations Conference, please be mindful that we are scheduled for the pre-conference session. I believe that's on Tuesday. And then we'll also be, again, doing another workshop relating to some of this information as well. And the project has already had several peer reviewers from across the country of different people that have helped us in kind of formulating all the different areas, not only those 4 main areas that we're focusing on, but also the curriculum as we have it set up right now. Right now we're addressing, I think, maybe 7 to 8 sections, talking about from the history of Taloa all the way down to things like community assessment. You know, how do you know if you're ready for this? How do you know if you're what kinds of things that you need to do to see if your community has the necessary resources to implement this? And then talking about ESA and the prerequisites. What are we doing in reference to requirements for prior prosecution, potential changes to community corrections, and so forth. And the other piece of that is also the ESA and the detention considerations. Again, the expanded tribal police authority under Taloa, the certification of tribal police to make federal arrests, those types of issues, as well as in Section 4, talking about the considerate collaboration to support the implementation of ESA. And we're really hoping that these monthly calls will help us do that, not only to start this collaboration process, but also be able to kind of put us all back together and openly discuss some of the issues that we're all facing individually. And then also other additional factors that we're considering is also the, as we said, the victim issues and the re-entry issues related to this legislation. And so I don't know, BJ, do you have anything else to add to that?
No, just to agree with Nan that we know good things are happening in many tribal communities with regard to this. It's just we don't know what the number of cases that have been prosecuted. Some of you may have seen that NCAI recently came out with a 5-year report about special domestic violence jurisdiction. Yeah, we need to gather data like that for tribes who are doing enhanced sentencing, because we need to show numbers in order to get Taloa fully funded, not only for courts, but for tribal justice centers, corrections. So we really would like to encourage anyone on the call that is familiar with, works in the tribal system, that's doing enhanced sentencing or looking to do it, that you join us in these calls so that we can share ideas of what's going on. Unfortunately, many times in tribal communities, we don't have good statistics to support all the good work we're doing. And this is an effort to show Congress that its trust in tribal justice systems is warranted, and that we should be strengthened in our exercise of our sovereign powers. So I think we wanted to turn it over and see if anyone had any questions or input into the project, or if you're interested in participating. So is that, Travis, is that what we're going to do now?
Yeah, of course we can do that. If you guys have any questions or anything like that, you can type it in the chat or raise your hand or use the questions pane. Either way, I'll monitor both of them. If you guys want me to, maybe we could put your guys' emails up, and if they want to contact you that way as well, we could do that.
And the session in Palm Springs is Tuesday afternoon. I think that's December the 4th. And it's free, open to any tribe interested. We really want to get any tribe interested in this involved in this project. And it helps us tremendously to get input from tribal communities on what's going on with regard to enhanced sentencing.
And even if you're not sure if this would be pertinent to your own community, we'd invite you to be in the calls that we're starting and just to kind of see if that's something that you're wanting to be a part of. And a lot of it, like BJ was saying, is that we're trying to gather the data that we know all communities have, and we're trying to be able to help piece those pieces together in a way that makes more sense to everybody, where we can utilize that data meaningfully. And so we talked about, you know, getting more resources. We can't do that without numbers. And I know that many of you deal with this every day and have those numbers, and we just need to kind of help each other tease those pieces out and be able to put something together. You're more than welcome to get hold of us. Are you going to be able to put our emails up there, Travis?
Yeah, I can. We could do it one of two ways. I can either throw them up real quick on a PowerPoint slide here, or we can email them out to the contact list. Whatever you want to do is fine, and we can do it both.
Yeah, that would be good.
BJ, do you want me to list your UND email or your
Sure.
Gmail?
Yeah, just the UND one would be good. Yeah, and we'd really encourage anyone that's interested, anyone on the call that's working for a tribal government interested in this, to let us know. We also have model codes that we can share of tribes that have enacted this, but overall, we're just trying to develop a coordinated way of sharing information so tribes can be successful in exercising this authority under TLOA.
Right now, on this project that we're talking about, this curriculum review, it'll be available to the communities. We're in the process of still going through each section and getting peer reviewers to go back through it, doing the writing of it. And so as soon as it comes out, we will make sure that we broadcast it out there. So if you're interested in being a part of that, please let us know as well.
Well, I've got a few chat questions here, but there's not any direct questions, just some contact emails and things I can send you guys if people are interested in being on the monthly calls. So that's great.
Great. Well, thank you very much, everybody. I'm very pleased that we had so many to come. We know this was kind of a last-minute thing, so thank you very, very much for taking the time to be with us today. And continue to keep in contact with us and let us know how we can help you or how you can help us mostly. So thank you very much on behalf of APTA, and thank you, BJ, for lending us your expertise in this area as well.
Yeah, thank you, Nan, and thank you for all the participants, and anything we can do to help anyone, just let us know. Have a good day, everyone.
And guys, I'll put my email up here as well, and that way if you want to continue to send me your emails or your contacts that you want to be on the monthly calls, we can do that.
Yeah, we'll send out another notice when the next one will be scheduled. So if you're if you can't get with us again, like Travis said, these webinars are recorded, so you'll have access to them. And so we'll get the word out hopefully a little bit sooner next time, so you can again join us in the next call.
Okay, there were no questions, right, Travis?
Yeah, I'm going through them now, but they're all just asking for emails and about the next webinars and things.
Okay.
Nothing.
Okay.
Okay, I guess if there's no other questions, and then we have our email addresses. So thank you very much, everyone, and we'll look forward to getting back with all of you that are interested in the next one. Thank you.
Thank you all. Bye now.
Bye-bye.
Thanks, Mary. I'll let BJ know you said hi. I think he left before I got the chance to tell him. But I talk to him like every other day, so